Sorry, Advocate Oda, she says it's not yet. You must go ahead. Okay, sorry. She said you will go ahead and she'll indicate if it's now clear. Thank you.
The next point that I wish to make is that the court summarized the facts in dispute and held that it all announced whether the firearm that was fired on the night in question was a real gun or a toy gun. This issue is not resolved beyond reasonable doubt by the evidence led in this matter. Consequently, the accused was incorrectly convicted of the charges. Then the court further erred in allowing the viral footage to be viewed without it having been authenticated. In this regard, the court took issue with the defense having relied on the footage during cross-examination of state witnesses and the presentation of the accused's case. The court subsequently held the facts which the court will rely on without giving any real regard to the viral footage and no further findings required regarding the said footage. So what we're saying is, Your Worship said it's real evidence, it was allowed, it was referred to, and eventually Your Worship said it's not inadmissible, it hadn't been proven. Then we say the court further erred in having regard to the state witnesses en masse and holding that they were credible, reliable, and truthful. And the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witnesses to indicate otherwise. This was premised upon the court having been very impressed by Colonel Ngwadleka, who was described as being a brilliant witness and had left no stone unturned. He had dotted every T and dotted every I. He had not made any mistake as far as the custody chain or the handling of the exhibits or serial numbers contained. The court finds him and all the above then as stated credible, reliable, and truthful. The extent to which the court had been impressed by Colonel Ngwadleka was further evident from the finding that he meets the criteria, in fact exceeds the required criteria in his thoroughness, and he can be, or is mentioned by this court to be not only an expert witness but a super qualified expert witness. That is the conclusion regarding Colonel Ngwadleka. This evaluation was in turn projected by the court to the rest of the state witnesses, even though there was no factual basis to do so. This in itself indicates a material misdirection by the court in its approach to the evidence of the state witnesses and the assessment of their credibility. In contradistinction, the court held that the defense witnesses, including Mr. de Klerk, were defensive and at stages argumentative. This is further borne out by the comparative analysis by the court of the evidence of Mr. de Klerk as compared to Colonel Ngwadleka, which was found to fall short and only be noted as mediocre. This biased approach to the testimony of the defense witnesses is further illustrated by the approach adopted towards the accused. The fact that he had stated that Mr. Mavundla should have been charged was utilized to discredit him. Additionally, he was found to have evaded many questions that had warranted a reply, and the court held that it became evident that the replies were entertaining, but however the pertinent questions asked remained unanswered. He was further criticized for relying upon the viral footage whereas nobody else was. Having held that the court had to establish whether the version presented by the defense was reasonably possibly true, regard was had to the statement in cross-examination that the firearm had been in Gauteng. In this regard, the court held, and I quote, "Now as to what happened and where it was kept, no explanation was provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equates to that specific firearm is booked out to him for whenever it is needed for him or by him. Since clearly it does not mean it needs to be on his body since he left it in Gauteng. In doing so, the court appears to have lost sight of the fact that this statement had been made by the co-accused's counsel in cross-examination. There was no basis to attribute it to the accused. These findings by the court indicate the application of a type of reverse onus upon the accused to prove his defense, whereas, as stated by the court, the accused version only had to be reasonably possibly true. Put differently, the application of the two cardinal rules by this honourable court had to exclude the accused version being reasonably possibly true. Then we say this misapplication of the onus is further evident from the court having, in its concluding remarks, confirmed the two cardinal rules that require the inference sought to be drawn to be consistent with all the proved facts and to exclusion of every reasonable inference from them save the one sought to be drawn. This could never be the case in the absence of any objective corroboration that one would have expected to be present at the scene, such as damage to property, injury to people, or at the very least an expression of fear by anybody from the many people that have been in attendance at the celebration. And finally, in relation to the conviction, Your Worship, what we say is at the very least, it cannot be said that now the court might find differently or have a different assessment of all the evidence led in this trial. Consequently, it is respectfully submitted that the accused is not only a reasonable, but a good prospect of success on appeal, and this application for leave to appeal against the convictions ought to be granted. In relation to sentence, Your Worship, we submit the following. We say that the sentence imposed by this Honourable Court is startlingly inappropriate to the extent that it induces a sense of shock. We say further, due regard being had to the prevailing circumstance at the time of the commission of the offences, and more specifically that they all relate to the same event in a very limited period of time that did not exceed 1 minute, all of the counts ought to have been taken as one for the purpose of sentence. There is no need or basis to impose separate sentences in respect of each charge, as this court did. We say further, insufficient regard was had to the personal circumstances of the accused. Most significantly, he is a 45-year-old first offender who was 37 years old when his offences were committed. He has not been convicted of any other offences in the interim. Additionally, he is married. He has 3 children and a wife to support. He is in full-time employment. He is also involved in community projects and regarded as an asset to the community. There is no basis to contend that he is a danger to society, thus ought to be removed from society. In this regard, Your Worship, I wish to highlight that no regard is had to the fact that he's led a blameless life during the duration of this trial, and he hasn't committed any other offence, and this was not taken into account in the sentence that was imposed. Furthermore, when it came to his community project, Your Worship questioned the social worker who testified, Ms. Thompson, in relation to the soup kitchen under a question to clarify, and it went as follows, Your Worship, just to indicate the approach of Your Worship. It's at page 163 of the record. Your Worship says at line 16, okay, let me leave that. I have only 2 aspects left, no few in fact, because if I had it before the time, it may have been a different story. The other issue, not an issue, but if you can explain. I think we go in the circle of a radius of 5 kilometers on each side of the court building. We're going to find about 4, 5, 6 soup kitchens. So, and this soup kitchen is specifically to the area of Mr. Malema is coming from. Ms. Thompson says, correct, Your Worship. The court says, so that is, what value must the court attach to that? Because I read it is from donations. Ms. Thompson says, part of, yes, and through the facilitation of the involvement of the accused, Your Worship. So Your Worship says, say it will continue. She says, it will continue most likely, yes. The court says, okay, so there's nothing special about the soup kitchen. Ms. Thompson says, there is. Then Your Worship cuts her, and Your Worship says, except that he may want to be very thankful that people are being served a meal that is outstanding. Ms. Thompson says, yes, Your Worship, and it was mentioned as part of the consideration in terms of the risk of reoffence. So the point we're making, Your Worship, is Your Worship undermined, with respect, the role that the accused makes to society. Put quite differently, Your Worship, neither, to my knowledge, does Your Worship or anybody else in this court have the right to claim that they started or initiated a soup kitchen, but Your Worship belittled that approach by saying, there's so many of them, they don't need him, whereas it was he who initiated it. So I needed to make that point. Turning to a more detailed list of what Your Worship had dealt with today, at the outset, Your Worship foresaw an application for leave to appeal. When Your Worship said, as to the firearm received from TSS, I dealt with this in my judgment, it will be an aspect for leave to appeal in the merits. There's no such finality in my judgment. This will rest until the leave to appeal. So it's quite clear, with respect, Your Worship, that you envisaged that there would be an application for leave to appeal, and that, with respect, permeated your judgment on sentence. When it comes to aggravating circumstances, Your Worship, you said that Advocate Caesar had highlighted and submitted that a custodial sentence was a normal, or was the right sentence, because this was a deliberate and executed with precision. And once again, Your Worship said these merits will be dealt with when we reach that point. So what we submit, Your Worship, is it was always envisaged by Your Worship that there would be an application for leave to appeal, and that this sentence bears that out. Your Worship also dealt with the accused being in a position of trust. Now, when we refer to a position of trust, Your Worship, is ordinarily a person is an employee who looks after money or an asset on behalf of somebody else. It doesn't cover the situation dealt with in this matter. And we've never ever argued that there's an absence of accountability and a breach of trust. But all of this, Your Worship, will come to the final quote that I'll address Your Worship on before I make my conclusion. And that's to the effect that Madam Justice is meant to be blind and deaf, Your Worship, and not have regard to the actual specifics of the person when sentencing in the manner that Your Worship did so here. Now, Your Worship also asked the following in your sentence. You said, the event was planned, the accused said so. I stand corrected on this aspect. It was the fifth celebration, first of its kind, and I was told that it is a well-established tradition. She said, Your Worship said, I'm unsure about this. Now, Your Worship could have clarified that. The evidence was there, but you do say in your sentence, you say as a misdirection. Your Worship went further to say it was planned, the whole event was planned and ended up in offences being committed. That can't be true. Now, with respect, we say it's a self-defeating argument, because if one says it was planned, then one must take into account that having been planned, there were no injuries, there was no damages, nothing untoward happened to anybody, and nobody expressed any fear. But that doesn't find any place in Your Worship's judgment on sentence with respect. And Your Worship then referred to the term of celebratory shots as an instance of sugarcoating, nothing more, nothing less. And we say in that regard, Your Worship erred, because it's Your Worship's finding as well. It was part of Your Worship's questioning of Ms. Thompson, that if it's my birthday, can I go down the street and start shooting? And she said no. You said, well, aren't those celebratory shots? So the court knew all along that it was dealing with the celebratory shots, and that was the instance that had been clarified throughout. It wasn't a case of being part of another offence like a murder or anything. And if one draws a distinction here, Your Worship, and this is where we say you erred as well, in relation to the case quoted by my learned friend in this division. Firstly, that predated the one that we referred to. So it was taken into account when the second one was a non-custodial sentence by Brooks. He had already had regard to that full bench decision and didn't feel bound by it. We say those circumstances are clearly distinguishable. The man was a member of a gang. He had been involved in shooting. He had previous convictions. There cannot, with respect, be any parallel drawn between that. He was in possession of an unlawful, unlicensed firearm, and somebody being handed a firearm and shooting a shot in the air, as is the conviction here. Your Worship also went into the merits of the matter when Your Worship said there should have been planning as to how, where, and what time you would take possession of the firearm, whereas there's no evidence to this effect with respect to Your Worship. Your Worship also said that such actions cannot be condoned by the court and used to justify shots as celebratory shots. Your Worship, when we're dealing with sentence, we're not asking for condemnation. We're actually asking the court to lend the sentence or the punishment of this matter being brought to court or not being brought to court. Now, with respect, Your Worship, the accused was asked on this. He was asked, who do you think is behind this? And he gave the version. He said, I believe Afri Forum is behind this. That was his version. This has caused a lot of consternation in this court. Even Your Worship yesterday said to my member of my team, Mr. Toby, why are you bringing Afri Forum into it? And all he said was, it's in their heads, I've got to. And then Your Worship left it. Once it had been said it was the state that had raised it, but it was unfair to attack Mr. Toby in that regard. Your Worship, also in regard to the financial aspect of this case on the taxpayers' pockets, with respect to Your Worship, that's a material misdirection. Could you imagine if we had to take everything into account in every trial, and with respect to become something of a political speech to refer to the women who come here for maintenance can't get access to the court, the children that can't get their grants? Well, why don't we blame them for the potholes and for the weather as well, Your Worship, because they're unrelated. The NPA, if anybody, ought to have seen that the right resource required. Here we sit with no aircon. is that the accused's fault as well, Your Worship, because the funds that were used for this trial weren't used for that. With respect, Your Worship, it's an improper approach to take, and we misdirect in that regard. It would seem that you are appealing more to the public and justifying the decision that you're going to make rather than using a legal basis to do so with respect to Your Worship. These are not relevant factors in relation to sentence. We cannot, on the one hand, as Your Worship did, and I've quoted you, say it's your right, your constitutional right to plead not guilty. You can have a trial. Oh, but by the way, you took up all these resources, therefore I'm holding you liable. That, with respect, is not a balanced approach, Your Worship. And Your Worship, this attitude is further borne out by Your Worship then carrying on through the time frame and saying, well, therefore the court is limited to what you're charged for and nothing more. Now, with respect to that implies that Your Worship wants to punish him for much more. We heard yesterday about all the different shots.
We heard yesterday about all the different shots.
There was only one shot in the charge sheet,
one bullet in the charge sheet. There was only one ammunition. There was only one firearm. So it seems that Your Worship has misdirected Your Worship self in relation to the magnitude of what occurred that day. And it would be premised with respect then on the video that Your Worship allowed and then disallowed at the end. So we say that that's an incorrect approach to the entire trial, and more specifically the sentencing procedure, Your Worship. And then Your Worship dealt with the politics and that it's not a political party that has been convicted here. It's a particular accused. But there's no need, Your Worship. If you say I'm holding you liable as the leader of the EFF, there's no need to say I'm convicting or I'm not convicting our party. It's self-explanatory. Then Your Worship turned to what Your Worship referred to as an uncomfortable topic, and said that Your Worship had heard all the witnesses, and Your Worship said that politics and law don't mix. They must stay in their respective lanes. Now, Your Worship, while saying that with respect, Your Worship, and in your attempt to distance yourself from that's exactly what you, with respect, made yourself guilty of. Because your reference to the public out there, to all the people that have suffered on account of this, was more of a political speech than a judgment on sentence with respect, Your Worship. And this, Your Worship, was also what was displayed yesterday, as I explained, in the confrontation between Mr. Ngai Toby and yourself relating to AfriForum, when it was the state who had said it referred to AfriForum. And Your Worship, another aspect that was highlighted and doesn't find any meaning is there was a debate yesterday, and even my learned friend wanted to continue further on the return of the firearm and what the correct procedure is. Your Worship, there can be no doubt, and Your Worship knows that Section 34, the court must make an order returning. The state can't decide halfway through a trial or at any juncture to return the firearm, and that ought also to have been part of Your Worship's judgment, that the rifle may be returned to its lawful owner. Your Worship identified the lawful owner in your sentence as Mr. Snyman, but Your Worship didn't go further and say, and he's now entitled to the return of his firearm because it wasn't handed by him, but it was given back to him after the event. But that wasn't taken into account. So a more benevolent approach would have taken those aspects into account. Now, the most distinguishing feature, Your Worship, between this Ngala Nzima case of Malindana, Your Worship, was there were victims. There was a dead child of 13 years old. There was an injured child of 13 years old. Here you have none with respect. There the judge in a higher court still found the compassion to deal with the bereavement and the loss of life and the injuries, and still not impose a period of imprisonment on a person that had shot people, which is distinguishable on those facts, but it's far worse. And the simple fact remains, Your Worship, that to this day, the challenge was put out to my learned friend and to Your Worship to find any case dealing with what you call sugar-coated celebratory shots, we call celebratory shots, where anybody had been charged for it. And Your Worship says that's not a relevant factor. We say it is with respect. If one can have regard to how many soup kitchens are in the neighborhood, one can have regard to how many times this actually happens in real life. And Your Worship, having berated the accused for taking so much of the court's facilities and time, then turned around at the end of it and said, each case is unique, everybody's equal before the law, and everybody has a right to a fair trial, so we're all equal. So, Joseph, how do we find somebody more accountable on the basis that is the leader of a party, but yet we say we're all equal before the law? And your worship said this specific accountability of public officers weigh much more. It doesn't mean you are not treated equally, and I don't understand that concept. Specifically, your worship, when we have regard to the decision that we quoted in our heads of argument in the Constitutional Court, and ironically dealing with the EFF versus the Speaker of National Assembly, where they stated as follows, in reference to the case that did away with the death penalty, worship, and they say, and I quote, at paragraph 235, it is after all the embodiment of the legendary Lady Justice, a dispenser of justice who's blind and deaf to images of any reports on the good reputation and notoriety of personalities before her, but never misses any legitimate and relevant legal or factual points for or against any litigant. So what we're saying, your worship, is that justice must be dispensed without fear, favour or prejudice. It's known, it's accepted by your worship. That includes Lady Justice being blind and deaf, your worship, and not overemphasising the position that a person plays in society when it comes to sentencing them for conduct, which conduct, as we've stated, your worship, was over within minutes with respect. Now just have a look. Worship also went further to say that the accused had been dishonest in his approach to the court, and with respect, your worship, there was not basis for that factual finding, particularly in relation to sentence, and this, your worship, then impacted on your worship's then finding that your worship could have regard to corruption cases and fraud cases dealing with dishonesty, and that goes back, your worship, to the issue that I raised earlier of being in a position of trust. It seems that reasoning permeated your worship's logic or reasoning throughout this matter, and we said that that is a major, irreversible misdirection on your worship's part. So in conclusion, your worship, what we say is that taking account of the crimes of which the accused was convicted, the interests of society and the personal circumstances of the accused, as well as the unique facts pertaining to this matter, the custodial sentence ought not to have been imposed. The imposition of the custodial sentence is startlingly inappropriate to the extent, your worship, that it induces a sense of shock. May I just listen to my colleague?
The police. Please, sorry, can you just a minute? We are returning. I couldn't hear with that last sentence.
I'm instructed by the authority to point out, and it's a valid point. If one has regard to the fact that there's never been a case of this nature, and we're all in agreement on that. So this is a novel situation that we seem to be dealing with judicially. So there's no sentence, there's no precedent that one can say, oh, well, the other case is exactly the same, and this is what they did for celebratory shots. If you look at Oscar Pistorius, if you look at all the other cases, there were people in a built-up room. He was given a non-custodial sentence for discharging. He wasn't charged with the possession, but it's very similar facts. This could even be regarded as a duplication. Possession, and there are cases that say possession of the firearm, possession of the ammunition is impossible without, I beg your pardon, discharge of a firearm with ammunition is impossible absent the firearm and the ammunition. Why should they be treated separately? And that's the case where with Oscar Pistorius, it's common cause factor. He received his friend's firearm. He shot that firearm. He wasn't licensed to possess it. He was thinking of buying one like that. That was the justification. Yet he was only charged with discharging the firearm. Here we have the very, very similar situation. Not only, your worship, did the state separate the charges, your worship then found him guilty of all three and gave different sanctions, different punishments on each and every one of those three charges, one being a 5-year sentence, your worship, with respect. So if we have regard to those and we do a comparative, it cannot with respect be said that this appeal is doomed to predictable failure. It has a very, very strong prospect of success, as we say. So we respectfully request leave to appeal against conviction and sentence, Your Worship.
Caesar, I'm not sure if you already, based on what you've heard, no, there's not. I was. Yes, I realized that's why.
It's my working notes.
Yes, no, you can't. No, I fully agree. I understand. I was thinking. That's why I'm saying. Has he listened, and then does he need a few minutes to prepare a reply? Because I've remembered. I don't require. I've listened. I don't need your working document. You need a few minutes, Advocate Caesar? Okay, thank you.
My understanding is correct. Section 309 of the criminal procedure where leave to appeal is applied from the government institution court to a high court. Insofar as the leave to appeal application is in respect of conviction and in respect of sentence, one of the factors that has been mentioned, if my memory serves me correct, and counsel can point out to me whether it is inaccurate, that Your Worship failed to take into consideration that the principles in Rex versus Blom relating to the only inferences relating to the incident in question, that the accused did in fact possess the firearm and that he did in fact fire those shots. This was our submission. In that regard, the court took into consideration all the evidence, including the video evidence, which the court deemed to be admissible. And like I've already said previously, that was enough evidence for the court to come to that particular finding that the accused did indeed fire that particular shot, and that there are no prospects of success relating to the conviction and sentence in this regard. If we deal with applications for leave to appeal, I've heard counsel say there are good prospects, but that's not the only requirement. The mere possibility that another court might come to a different conclusion is not enough to convince the trial court to grant leave to appeal. The reason for that, why the courts have taken such a view, if Your Worship is of the view that the conviction was correct, allowing an application for leave to appeal will absolutely amount to a waste of judicial resources when there's no prospects of success. I submit that counsel might have an arguable case, but if there's no realistic chance, insofar as the conviction is concerned, that he will succeed. It has been pointed out in so many cases, the Supreme Court of Appeal has stated what is the test of reasonable prospects of success, postulates it's a dispassionate decision based on the facts and the law, that the Court of Appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal, and that those prospects are not remote but have a realistic chance of succeeding, most required to establish than that of a mere possibility of success. A mere possibility of success, an arguable case, like I said, or one that is not hopeless is not enough. This is basically what I said counsel have argued before, Your Worship. There must be a sound, rational basis to conclude that there is a reasonable prospects of success. insofar as the sentence is concerned, that before I go there, I just want to say the court has thoroughly considered all the evidence. Like the court pointed out earlier, the court had a long judgment dealing exactly with every issue that has now been raised by counsel, whereas the court has made those findings in respect of each of the points raised. It's my submission, insofar as the conviction is concerned, there is no reasonable prospect of success and no realistic chance that it will be overturned on appeal. Insofar as the sentence is concerned, Your Worship is of the view that I did request that the 15-year sentence must be imposed. I also provided alternative sentences which might be imposed to the accused. I'm satisfied with the sentence that was imposed by this court. As a matter of fact, I find it to be fair, and regarding to the facts of this case, there's also no prospects of success relating to this particular sentence, that a different court will come to a different conclusion, and that the court should dismiss this application. The issue with bail, I will deal with Your Worship as we go along, depending on the court's finding whether there are indeed prospects of success or not. Thank you.
Start out with the arguments made about the correct test. It seems that my learned friend wishes us to argue that your worship is wrong, but we don't have to argue that you are wrong. It is on appeal that we will argue that you are wrong. What we are dealing with today is merely a question of whether there is a realistic probability that another court might come to a different conclusion. In other words, is there a realistic prospect that that will be the case, both on the questions of fact and on the questions of law. So it's crucial to underscore that test. And the exercise is also not a repetition of the case that your ladyship has had. Your ladyship is now functus officio in relation to your judgment. So we don't have to persuade your ladyship that you were wrong. We simply have to show that someone else looking at the same facts might come realistically to a different conclusion. The only argument made by the state, and it's important to examine their case, what they have said now, is around R versus Blow. That's the only thing they have said. Now, your ladyship, if you contrast that with the case that has been made on behalf of the accused, R versus Blom is one aspect, but there are so many other grounds for leave to appeal that have been advanced. The reality, your worship, is that none of those have been responded to. What you have is just a generic submission that there is no reasonable prospect of success, and there is no reasonable likelihood that a different court looking at the different facts might arrive at a different conclusion. So in effect, you are then not dealing with an application on conviction that has been seriously contested by the state. They've raised only one ground and they've ignored each and every ground, and they've put them under this omnibus category that there is no reasonable prospect. So that's point number one, that actually this is not meaningfully opposed by the state. Point number two is that what that does is that it therefore leaves those grounds uncontested. Now, that has serious implications then for your worship's weighing and assessment. So if you have an accused person that gives you 10 grounds, and you've got the NPA that responds to 1 ground, and that leaves 9 grounds unopposed, in effect, what does that then do to the court? Is the court now supposed to fill the gap left by the state? I'll tell you why they have taken that approach. It's because they themselves accept that this is a strong application for leave to appeal on fact and on law. So if that is the case, then that the only logical deduction to be drawn from the unserious opposition is that actually this is a cogent application for leave to appeal. Then it leaves your leadership's role very easy, because you don't have to decide whether you were right or whether you were wrong. Someone else must decide that. The job is very easy. The High Court must make a fresh evaluation of the evidence and make a determination whether the convictions were safe or not. That then takes me to the question of sentence. We have a similar approach taken by the state. This is what they said. I noted it down. They say, we've asked for 15 years, we've got 5 years in one and 2 years in the other. We are very happy with that. Of course they are. But the question is whether there is a realistic chance that someone else looking at these facts might arrive at a different conclusion, or whether or not there is a reasonable likelihood of success on the appeal against sentence. If I have to weigh, and I'm not doing that weighing now, the two appeals, the conviction and the sentence appeals, I would say the sentence appeal enjoys the most excellent prospects of success. One, because you are not dealing with a field that is occupied by judicial precedent. And it is correct as a matter of law, if you are not dealing with a field that is occupied by consistent precedent, to say the higher court must relook at it. And that is not because your worship is admitting that you were wrong. Your worship is simply saying there are different views in this field of law, and let the higher court relook at this and make a determination. Just take one example on the discharge alone. Look at the 4 cases we looked at yesterday, if you remember all of them, Your Worship. You know, none of them resulted in direct incarceration, none, 0. And you look at the case presented by the state, they are unable to point to a single case of a discharge that results in direct imprisonment or discharge alone. Then you look at your leadership's finding, count 2, which is the discharge count. You sent Mr. Malema to 2 years direct imprisonment. Now, can you be confident that there is no other court that realistically may come to a different conclusion? I think that if you took that view, your leadership would probably fall into an error. Even if you look at count 1, the possession charge, it is correct what my learned friend said, that these cases differ. Yesterday I took your lordship to 7 different authorities. I picked 3 where there have been fines of as low as 2,000 rands in circumstances where there have been injuries. So even that, an imposition of 5 years is not a safe direct incarceration, no option of a fine, no suspension. It's not necessarily a safe imposition. So it would be proper for your leadership to say, look, I've done my job. Now let the High Court relook at this matter and decide what it wishes to do. I'm not going to complain about the declaration that Mr. Malema is not fit to possess a firearm, because it follows from the convictions. If those convictions stand, then there's no problem with that. But if those convictions, there's a realistic chance of setting them aside, then as a matter of logic, the balance follows. So what am I saying then on sentence? I'm saying to your leadership that it is possible that someone else, realistically possible, that someone else will say this sentence induces a sense of shock. Now we can say that, my lady, without fighting with your leadership about who introduced politics in court. We can say that purely on judicial precedent. And we can say that purely on application of legal principles. And when your leadership considers this, your leadership, we accept, will be dispassionate. And your leadership will be blind to the politicians sitting behind you, and will be looking at the accused without identity. And then decide, well, does he deserve to have his case re-evaluated by a higher court or not. Now, if your ladyship even refused that, then we will say that your ladyship is not acting in accordance with the oath of office. But we trust your ladyship that you will act in accordance with the judicial oath of office and send the matter to the High Court, let them re-evaluate it. They might agree with your ladyship, but there have been many instances before that you think you are right. I've been there myself. I think I'm right, and then five judges sitting in the Supreme Court of Appeal say, sorry, acting judge, you were wrong. And that's where we are today. Your ladyship may be overturned. And so we ask, therefore, with respect, this is a discretionary matter, but at the same time, it is a matter of application of settled legal rules. So we would therefore ask that you send the conviction, you send the sentence to the High Court, as you please. I just wanted to finish our speech.
Yeah. Okay. I think we can return before 1. Since I've heard what you've said, Advocate Odes, and thereafter Advocate Nkaitobi and Advocate Caesar. It's not a difficult issue as you've stated. The law is clear. I'm going to extract the relevant parts and return, can we say 12:30? That will give me sufficient time. Please, just a minute. I'll proceed now. Just 1 minute. My minutes were few, so I just need to solve a few minutes. Take 1 second. All right. You may be seated, and the court will proceed with the leave to appeal application brought by the defense with regards to conviction as well as sentence in this matter. Firstly, then, for record purposes, the court needs to be particular. The matter is before court in terms of Section 309, capital B of Act 51 of 1977. Therefore, leave to appeal in respect of conviction and sentence. The said judgment was handed down was it 1 October 2025, and sentence imposed today, 16 April 2026. The defense being Advocate Hodes SC and Advocate Nkaitobi SC had immediately after sentence indicated their intention to seek leave to appeal conviction and sentence. I will deal with 2 case laws that specifically is used daily by our courts dealing with matters of this nature. And I will refer to State v. Mabena and another, 2007, 1 SACR 483, Supreme Court of Appeal decision. The following was noted. It is the right of every litigant against whom an appealable order has been made to seek leave to appeal against the said order. Such an application should not be approached as if it is an impertinent challenge to the presiding officer concerned to justify his or her decision. A court from whom leave to appeal is sought is called upon merely to reflect dispassionately upon its finding after hearing arguments and decide whether there is a reasonable prospect that a higher court may disagree. In this regard, the only comment the court will make is with regards to one aspect as highlighted by Advocate Hodes, and that is that the court had anticipated the appeal. On that, I would say it is the duty of every trial court who imposes an appealable or hands down an appealable judgment or sentence to at all times be aware you handed down an appealable sentence. So it should be the norm to anticipate an appeal, not the exception. Further then, the court will highlight that in State v. Mackenzie 2003, 2 SACR 619, Supreme Court of Appeal, the decision stated that where the appeal, it's not relevant because the defense was not vague in the grounds that they raised. It didn't merely state a general error on the side of the court or the presiding officer. It made specific points. And the requirement according to that case is that the appellant must do so and state the grounds clearly and specifically, and that has been done. As to what then constitutes reasonable prospects of success, Plaskett A.J. in State v. Smith 2012, 1 SACR 576, Supreme Court of Appeal decision, describes it concisively as follows. What the test of reasonable prospects of success postulates is a dispassionate decision based on the facts and the law. That a court of appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal and that those prospects are not remote but have a realistic chance of succeeding. More is required to be established that there is a mere possibility of success. There must be a sound, reasonable basis for the conclusion that there are prospects of success on appeal. It is also noted by this court, and I want to place it clearly on record, that in a criminal case, a magistrate or the trial court should not take the easy way out and leave everything to state counsel or the appeal court when it is the correctness or otherwise of her or his decision that is at stake. When confronted with appeal, the trial magistrate is duty-bound to make an honest reassessment of his or her decision in light of the appeal. It is helpful to everyone concerned to know whether or not the trial magistrate still abides by his or her decision despite the appeal. If for some reason the trial magistrate has had a change of heart, it is more honorable to say so than to adhere to an indefensible decision. In doing so, it may save precious time and costs to all parties concerned, and the ends of justice cannot be served by prevaricating and being non-committal when the liberty of a citizen is at stake. Therefore, the test is straightforward, namely, whether there are reasonable prospects of success in the envisaged appeal against the conviction, rather than whether or not the appeal ought to succeed. That is, let me stop there. That is the general principle applied by courts with regards to an appeal. Following fashion so that it's not repetitive, and state as follows. I'm going to deal with conviction and sentence in one ruling. Therefore, a court will have to be careful in its judgment in a leave to appeal application not to influence the outcome of an appeal, and for this reason is curtailed in dealing with the merits to the limited extent necessary to explain its reasoning for granting or not granting leave to appeal. So So for this reason, the court will refrain from any further comments as to ensure that there is no interference with any proceedings that may follow. With regards to the clear direction from case law, this court is to state clearly that whether it stands by its decision to convict the applicant for the reasons already mentioned during the judgment, and to state so clearly, in this regard, Mr. Malema, the following ruling is made with regards to the application. With regards to the decision with regards to conviction, this court abides by its decision as stated on record. This court has not had a change of heart and clearly stands firm on its decision to convict. Therefore, leave to appeal in respect of conviction is not granted. I've not finished, please. However, with regards to sentence, after listening carefully to the address placed on record, in respect of sentence, there is always a possibility that another court may come to a different conclusion regarding sentence. Therefore, this court does not have any intention to stand in the way of such a possibility. Safe to say, no, I'm not going to add that. The court will not stand in the way, and therefore leave to appeal sentence in this matter is granted. Thank you.
Been on bail since the 27th of November 2019. So it's 7.5 years ago. He was on warning, I beg your pardon. The accused was on warning. He's abided by every request to be at court, every order of the court. Based on the Hudson, Anderson, and the Nadu decisions, we'd ask for reinstatement of his release on warning, Your Worship. I understand it's not opposed by my learned friend, but I'll allow him to confirm it. Thank you, Your Worship.
And that he be continued to remain on warning.
Yes, Your Worship, please.
Thank you, Advocate Otis. Advocate Caesar?
Released on bail. I hear differently now, but I also have no objection if he is released on warning on this regard. Thank you. We had an agreement.
Be difficult. I also, in principle, do not have any objection to the request. Normally when we go to the aspect of bail pending appeal, there are normal conditions that is applicable which the applicant will have to comply with. So I'm also in charted territory now when the status remains on warning as to how we'll deal with the conditions.
Bishop, I think the normal case would be remains on warning until the appeal is prosecuted, faster prosecuted,
Yeah.
it's an adverse finding.
Yes.
Hand himself over.
Within 7 days it will remain the same, no? Okay.
7 days.
7 days, yes. Just for my own, sorry Advocate, it's for my own, because as you are well aware, any court who grants appeal or whichever petition will follow, I'm not sure, needs to keep a register with the progress. So is there a date which we may agree on, which there can be an email or an update as to the progress, merely to know it's filed, and that is the end of my involvement.
The appeal against sentence will proceed, but will still be petitioning as well after.
Yes.
For leave to appeal against the conviction, which is within, I believe it's 15 days, which is 3 weeks, because it's normal.
I think on my side I will have to prepare, or we will have to prepare quite a lot of documents for you for that procedure. It's why I'm asking more or less, because it's a time-consuming exercise, so that I can, we'll start getting it ready in any event, I think. 21 days.
That's 3 weeks. It's 15 court days, that's correct.
Okay.
So if we could set the date within 3 weeks of now, Your Worship.
As the court pleases, Your Worship, I think that concludes our round.
Bye-bye.